All right. Hello, everybody. We are live here with Joseph and Hall, and we're going to take today to give you some updates on what's going on in the world of immigration, as well as to answer all your questions. So if you have a question, feel free to post it in the chat, and we will answer it as we go along. If we don't get to it while we're going along, then we'll answer it at the very end. So a lot of interesting things happened this week in the world of immigration. Let's start with the Go hearing. Aaron, you and Chuck argued this case this week. Tell us first, what is the Go case, what it's about, and what happened this week?
Sure. So the Go case is for selectees of the diversity visa lottery for the fiscal year 2021. And we brought the case because the Department of State is just not scheduling interviews for these people and not processing the cases fast enough. There were only 55,000 visas allotted by Congress, and the government is not on pace to adjudicate more than about, 10,000 by the end of the year. And then once the end of the year hits, the fiscal year on September 30th, they disappear if nothing else happens, if we don't get court intervention. And so that's what we're doing on behalf of the Go plaintiffs. This week we had a status conference, and the status conference was just to get a agreement from the court and the parties on an expedited briefing schedule. Because of how time sensitive this case is, we want a final decision as soon as possible. And so we did that. We got that agreement, and we got an order from the judge. The government is tasked with producing an administrative record and a motion to dismiss and for summary judgment, all by May 21. Then we get our responses and our motion for summary judgment on June 7th. Then the final briefing wraps up by July 2nd, and we have a hearing already set for the afternoon of July 13th. So that might not sound really fast, but that is warp speed. And we hope to have a decision soon after that. So we're very pleased with how quickly that's happening and how it's all gotten lined up, and we'll be ready to get a decision from the court hopefully shortly after that hearing.
Aaron, one of the questions that came up on this case is, one of the things that happened at the hearing is the judge asked if the case should be consolidated with Gomez and Aker, and to have one decision on DV2020 and DV2021. And there's some concern if, what will happen if other cases are consolidated with this case? Mm-hmm. Will that impact the plaintiffs in our case?
Yeah, so as far as Gomez and Aker, those are the DV2020 cases. And those have already been fully briefed and are before the same judge, Judge Mehta. And so Judge Mehta was asking, hey, since these are, very similar, if not the same issues, should we just consolidate it and hear arguments on this in one hearing? And at first, I think during the hearing, Chuck said that, he could see how that made some sense. But we've since filed a notice saying that we would just prefer that the judge make a decision as soon as possible in Gomez Aker, and then we will go to hearing separately on Go. So I don't think that those are going to be consolidated.
Yeah, one thing to note here, however, is that we really don't have control over whether cases get consolidated. In other words, we may not be the only lawsuit. I don't anticipate we will be the only lawsuit that challenges DV 2021. I anticipate there will be a whole host of them. Yeah. And, they may try to glom onto our lawsuit because we're the first ones to file. And frankly, they should be related for judicial efficiency. We're not going to be able to fight that. So it is true that if a case gets consolidated with us, it may have an impact on you. Also, we have no control over if a case gets consolidated, whether there's a motion for class cert that gets filed. If a motion for class cert gets filed, that also could impact everyone. All I can tell you is that our loyalty, our duty of loyalty, our representation is with you individually. And so our objective and goal is to get your cases heard as quickly as possible as our named plaintiffs. Okay, anything else on Go before we move on to any other updates?
No, I think that's it.
All right. Let's talk about a big case that came out of the Supreme Court this week. Jennifer, tell us about that case. And first of all, give us some background on what the issue is in this case and why it's so important, and potentially what the implications are for the future, what could happen with cases that have lost under this issue?
Sure. So last Thursday, the Supreme Court issued an opinion in, I might butcher the saying, but Niz-Chavez v. Garland. And so the background here, this has been in litigation for a while, but there's a common defense of deportation called cancellation of removal. And to qualify for cancellation of removal, there's a lot of requirements, but one of those is that you've been in the United States for a certain amount of time. It's 10 years if it's non-lawful permanent resident cancellation removal, or 7 years for cancellation, or for permanent resident cancellation. And there's something called the stop time rule that says for cancellation of removal defense, the time in the United States is cut off when the government serves the notice to appear that places the person in removal proceedings. And that statute, the stop time rule statute, defines what the notice to appear has to have in it for it to qualify as a notice to appear and to stop the time. So what we've been seeing for a while now is that the government has been issuing these notices to appear without that required information. They've been putting like to be set for the time and place that removal proceedings will be initiated or, be held against the person. And so this has been in litigation. A lot of attorneys, we've filed a lot of arguments against this, saying that a defective NTA, notice to appear, that doesn't have the time and place of removal proceedings doesn't serve to cut off that time. And that the time continues to run beyond that time to the final hearing. And so there's been a number of cases under the Board of Immigration Appeals, the 10th Circuit, going back and forth about this, and pretty much every circuit. And so last week what happened is the Supreme Court finally made a decision saying that if the notice to appear is missing that information, it does not trigger the stop time rule for the purpose of cancellation. So this is huge for people who are applying for that form of relief in immigration proceedings and removal proceedings. And I mean, this affects like thousands of people. There's tons of people in removal proceedings that are eligible, that would be eligible for this issue, and so now they will be eligible. I don't know if anybody else.
And there was also like a whole host of intervening litigation where ICE came back and said, okay, we get it. So, so this notice to appear is insufficient. It doesn't contain the information. But subsequent to that, we file a notice of hearing with the court, and the court issues that notice of hearing that does contain that information. And their argument was, the combination of those two documents perfects service. So that second document should serve to cut off time. And what Gorsuch, which is we can talk about the fact that he authored this decision and what that means, but he essentially said no. The regulations are very clear that it must be contained in one document, and that one document must be served on the person in order for proper notice to happen. And so it really kind of collapses all the litigation has happened back to what the original argument was, which is this document itself, under the regulation, should provide all the elements of notice that are required in order to comport with due process. What about, so I guess the question then happens, there has to have been numbers and thousands and millions, thousands and thousands of cases that have lost on this issue, and potentially could be reopened now. Yes. Also, there's a bunch of cases, I'm sure, that are up on appeal at the 10th Circuit or other circuits or even at the BIA that should now be remanded for this issue. So how does this impact all the cases that are in the pipeline and possibly have already lost based on this issue? And this is for anyone, because I don't know the answer to this. I want you to educate me.
So, I mean, on that issue specifically, I mean, there's still a lot of confusion from DHS about what happens next. They're still kind of putting their guidance together about, what are we going to do with all these cases that are on appeal. I think though that there's also some potentially bigger implications there that, I mean, they're not directly addressed in the opinion, but I think they kind of underlie the entire premise of the opinion. If we're saying that the notice to appear, the document that starts removal proceedings, it's basically the indictment if it was a criminal case. for saying that's defective, does that mean that the removal proceedings themselves are defective, that they are voidable by not being given sufficient notice? I think that's an issue that still needs to be litigated, but where you don't have, like, let's say we do a lot of federal cases, as everybody here in the questions knows. If we filed a complaint and the complaint didn't have all the information that it was needed to start the case would get kicked out, because we need to, under the law, provide certain information to the defendants. Analogizing here, if the respondent isn't given all of the information in the equivalent of the complaint or the indictment, does that mean that the case should be kicked out? I think that's a question that remains to be answered, and it'll be strange and exciting to see where this goes.
Yeah. To chime in on that, I think what's interesting too is we've been seeing a lot of these fake dates on notices to appear, and I wonder what's going to happen with that now too, because there is a date on there, but we're finding that the court is not actually getting notified of those dates. So
it's like a place filler for the court to comply.
Yeah.
For people who are up at the Board of Immigration Appeals on this, I think that they should get their cases remanded if this is the only reason that their case was denied by the immigration judge. But I would just caution people that they need to be careful and thoughtful when they file their motions to remand, or their attorneys do, because the Board of Immigration Appeals in the past has tried to kick out the case or deny the remand for other reasons, such as, okay, maybe you could meet the continuous presence requirement now, but there's no evidence of hardship in the record. And so it just needs to be, the judge's order needs to be carefully analyzed right before remand is sought, to make sure that you have all your bases covered. And then, like Jeff said, there's a lot of people whose cases are complete. They already lost on the immigration judge and they didn't appeal, or they lost at the Board of Immigration Appeals and they didn't appeal, and now their cases are closed, but they're still here. And the question is, well, with this change in law, can we move to reopen the case because of the way the agency was unlawfully interpreting the statute before? And I think that's an open question. I think there's going to be a lot of motions filed on that and a lot of litigation. So it'll be worth watching.
So I have two questions for you, Aaron. The first question is, what will Joseph and Hall be doing if we have consults that say, I want to reopen my case? What will our position be?
I mean, I think it's any one of those cases is going to be dictated by the circumstances in the case. So, for example, if somebody's order shows that was the one reason that they were denied, and then they would have accumulated enough presence before the BIA denied their case, they might be in a different circumstance than somebody who was denied by the judge after 5 years of the required 10 years. The BIA threw out their case after 7 years, and it's been final since then. And now they've accumulated 10 years since then. That might be a different circumstance. So I think each case is going to have to be evaluated. And then what we'll have to do is just, let people know that we will push every aggressive argument that there is. But there's some uncertainty about how the Board of Immigration Appeals, the immigration courts, and the circuit courts are going to treat these motions.
Yeah, one other thing that I think we could argue, and I understand your point about remanding and getting kicked out for other reasons, but it seems to me that if the issue really is that the notice to appear never stopped time, then that also means two corollary things. It also means hardship the hardship determination is still a living determination. Mm-hmm. And so it's not possible to remand just for the stop time rule without the corollary of considering the hardship that is accrued. Now that could cut both ways, right? Mm-hmm. One way it could cut is there is no hardship anymore. The kids are adults now, and so that could cut both ways. I could also see an argument with regard to good moral character, right? So you want to assess, has good moral character improved or not improved during the time that it's happened, right? So I agree that it's sort of like new assessment of cancellation from the beginning. But if you have this issue, you need to be calling our office. Like the phone should be ringing now, because now's the time to be assessing these cases for future cancellation.
And on that, a final note on that is that when you're filing a motion to reopen a case based on a change in law, there's a requirement that you do it quickly after the law changes.
Mm-hmm.
So if you do it a long time after the court decision, they're much less likely to reopen your case. So Jeff's right that if that's your situation or the situation of somebody that you know, then the time to move is now.
All right, we're gonna move on to the next topic now. Let's talk a little bit about business immigration. Zach, tell us what's going on in the world of business corporate immigration.
Of H's again. All I talk about. As soon as I'm not available for Facebook Live to talk about H's, we have to cancel the whole thing. Sorry about last week, everybody. Anyway, so a case that we did not file, but that friends of the firm and the American Immigration Lawyers Association did file. It's a case called Edakuni. It was basically challenging, in very broad part, the massive delays that spouses of H-1Bs, of L-1s, and of E-2s, various I guess work visas are experiencing and trying to get their extensions of status and then trying to get their work permits. We've seen a real just massive jump in the processing times it's taken for an H-4, for example, to get their work permit from a couple of weeks to being, I think last time I checked, it was 14 and a half months. And you're not even able to apply for a renewal of your work permit until you're within 6 months. So, you're like necessarily going to be out of work for, 7 to 8 months, just based off of the published processing times. There've been a whole bunch of these kind of like individual suits about, getting these cases moving. But this was kind of the first one to say, what's going on? Let's get this, practice fixed, fixed. And yeah, so we just got an update from the Service Center Operations Director. They're saying that as of May 17th, they're no longer going to be requiring biometrics appointments for H4s, L2s, E1s, E2s, E3s, really the spouses that are being impacted by this most broadly. This is going to just dramatically cut down processing times for EADs and for renewals really across the board for spouses. So it's really exciting. It doesn't apply to everybody, and it's not a permanent, I guess, policy. It's supposed to be in place for 2 years, and then they're going to reevaluate at that point. I guess my guess is that it's going to be kind of, I guess, put into place in perpetuity after the 2 years. But very exciting. Hopefully we'll see all these processing times really come down, and people will finally be able to start keeping their EADs and working. Really, this whole policy came about from Trump era 2017. After Buy American, Hire American, they're trying to really cut down on the ability for H-4 spouses and other spouses to get employment authorization. It was put on the regulatory agenda to remove the ability for H-4s to get EADs, for example. Never got put on the books, but all these other kind of artificial hurdles got put up along the way, including these biometric requirements. So by removing these biometric requirements, we're kind of seeing these hurdles being removed, and we're seeing a step in the right direction, I suppose. And I guess we want to keep seeing those nice steps from USCIS, and it looks like they're on their way.
Zach, you know me, I already have questions. So I guess my first question is, one of the things that holds up processing of the initial application, whether that's an extension of an L, is often biometrics on the 539. So can we anticipate now that, biometrics are gone, that we may see concurrent processing of those two applications, the I-129 and the I-539?
So the I-539 is dependent on the I-129 being approved. So I suppose we could see more or less concurrent processing, just because the amount of actual man hours that goes into processing a 539 or a 765 for your work permit is really low. It's a matter of a couple of hours. So we could see, the I-129 is approved, and then really a couple of days later, the I-539 is approved. But a prerequisite for the 539 to be approved is that the I-129 is approved. So I suppose it's not exactly concurrent, but could be pretty close.
Anyone want to chime in H-land so Zach doesn't feel all alone?
Talk about.
No? Anything else?
Didn't think so. Okay.
All right. Well, let's shift over now and talk about our favorite topic, the proclamations, the big ban. So let's switch to Luke. Luke, first of all, anything new in the world of proclamations?
Yeah, there sure is. New proclamation is out. Probably not a huge surprise, just given how things are going in India with COVID. But on April 30th, President Biden issued a new proclamation, which goes into effect May 4th, so already went into effect. And this is very similar to the other geographic COVID proclamations that he issued. So it restricts the travel of non-immigrants to the U.S. from people who have been in India for the 14 days preceding their entry into the U.S. This is pretty much, very similar to the ones that are in effect for the other countries. We have Brazil, South Africa, the Schengen countries, China. Very similar in that, a lot of people are exempt from this proclamation. So if you are seeking an immigrant visa, if you're seeking a fiancé visa, K-1 visa, you're exempt. This doesn't apply to you. And I would say, while it doesn't apply to you, I think, another question is just maybe practically it doesn't apply to you, the proclamation, but in effect, capacity at the embassy and the consulates in India for processing these visas is likely way down. So even though the proclamation may not apply to you, certainly people are seeing still delays in their cases if they're not subject to that proclamation.
All right, Luke, I have questions.
Yeah.
So question number one is, so we've seen this happen in the Milligan case where Johannesburg got added, the consulate in South Africa. So the first question is, with regard to the Milligan case, how is this proclamation impacted one way or the other on Milligan and vice versa?
Yeah, we saw that in Milligan, they came out with a proclamation for South Africa after the case was filed. In that case, the government counsel, they basically agreed in their briefing and they said, Judge, you've made this order regarding the other proclamations being unlawful in issuance in restricting the issuance of visas. Because this proclamation is very similar, we're going to agree basically that all the folks who are subject to the proclamation in South Africa are similarly situated to folks who are subject to the other proclamations. So I would imagine the government would have the same position with this new proclamation for India.
I think that's right. I think that, the government is going to take the position that with regard to India and K-1s in India, the proclamation is unlawful. It does not suspend the issuance of visas. Great. Okay. I'm going to give you some questions on Milligan, if that's okay, Luke. This is the first one, which is, tell us about the status report that's supposed to happen today.
Yeah, so today we're expecting the government to respond to our complaint. So their response is due the 6th. In the past, typically when a response is due, we'll expect to get it at the very end of the day. So I would expect probably around 10 p.m. Mountain Time, we'll get a response, the government response, and then after that, we'll have 30 days to respond to the government. So in that response, the government is really going to lay out their position. We have these mandamus claims in the Milligan lawsuit, and so the government is going to be responding and sharing what's their position on these claims that we're making.
Yeah, so the world of status reports is sort of over at this point, right? So we are kind of entering the last phase of Milligan litigation, which is actually litigating the issue. So if you recall, there's the proclamation, which we won on the injunction, which is preliminary relief, right? We won, the judge at least initially said, I think you're going to win on this issue with regard to the proclamation. I don't know if you're going to win on this issue with regard to mandamus. So now the government is going to come forward and say, Judge, here's why you should dismiss the case with regard to the proclamation and with regard to the remaining mandamus claims, because remember, we've voluntarily dismissed a lot of the mandamus claims for people that have been issued. So for the remaining mandamus claims, here's why the case should be dismissed. So there's no status reports anymore. We are taking this case to the finish line at this point. All right, let's see, another Milligan question. Okay, here's one. Any knowledge if the consulate in London is giving non-plaintiffs interviews? The Department of State statement said K1 has NIE, blanket NIE, and embassies made a statement saying they sent out instruction letters to applicants.
They are, yeah. I mean, we've heard from people who are not plaintiffs in Milligan, who don't have any who are not plaintiffs in any lawsuit, that are receiving interviews. I mean, a lot of those cases, they're going back to cases that were documentarily qualified, way back prior to the pandemic. But they are scheduling them.
Yeah, I mean, the government has, their position has changed as with regard to, whether K1s have priority or not, regardless to whether named plaintiffs have priority or not. That position has changed. We are now at a position where, first of all, K1s are no longer highest priority. I mean, that's the first thing you need to know is that as of last week, K1s are now tier 2 for priority processing. They're no longer the highest priority. The second thing is that Department of State's official position now is that named plaintiffs don't get to go to the front of the line. They're on a first in, first out basis. Now, our challenge to that is prove that. I mean, where is the line, first of all, and how do you determine the line? Is it determined by notice of action date or documentary readiness date or what? I mean, because some of these cases have been documentarily ready, but still pending at NBC for over a year. So to us, the line really doesn't mean anything, right? And so at the end of the day, our position is that the judge, you have to move forward on these cases or we have a litigable claim. All right, let's see. Any other Milligan questions here? Okay. I think that's, okay, here's another one. This is really, this applies to everyone. Milligan, Kinsley, Penn, Blinken, all of them. What if your NBC and embassies just continually ignore your emails? Your contact forms get generic responses, blah, blah, blah. What do you do with regard to that?
Keep sending the emails, keep getting the no response, and it's evidence that we can use.
Yeah, so a couple of things here that other people have done that are effective. So first of all, if you're the US citizen petitioner, you live in a district with a congressional representative and a state senator. And every house, every representative, and every senator has what's called a constituent services person. And so if you go on their website, they will have a link to their constituent services person. Sometimes they'll have a form that you can fill out right online that, you tell them the problem, you tell them the agency you're dealing with and what your problem is. And their job is to get cases unstuck. They cannot get a case approved but if it's not moving, they can help get it moving. So that's the first thing that you can do non-legal is use your representative and senator. They work for you and their main job is to interfere when the government's bureaucracy is not doing their job. So that's the first thing I would say. The second thing I would say is yes, continue to send emails to both the NBC and the London embassy. It's our suggestion that you copy both the NBC and the embassy in those emails so that they are aware that you're communicating with both sides. We have found in the past that they blame each other for not moving on cases. So it's better if you're at least corresponding with both of them and letting them know that you're trying to get this moved from both ends. Other than that, what we're doing on our end is we are reporting frequently to the government on cases that are moving and are not moving. We're also reporting those to the court in status conferences. So I know that that the perception is we file this case and the next day you get relief. The truth is these things take time and you have to be patient. We are slowly whittling away at the Milligan plaintiffs, and we will do the same with all the other cases as well. All right.
I think we should just give the update on Kinsley that we're already, talking to government counsel about the plaintiffs in the suit. So it's not. I guess that's already moving that communication with the government. So it's not the publicly filed document, not stuff that we're sending out to all the plaintiffs, but that is happening, and we expect movement there because of that.
Yeah. Let's talk about some of those cases because we have some questions about the specific cases. First one is Penn V Blinken. Rio has started processing K1s. What could the plaintiffs of Penn V Blinken expect? Who is the head lead on Penn?
I am. That's a good question. And Jeff, maybe you want to help.
Well, first of all, do we know? Do we have the first thing for all plaintiffs of all of our cases is there's a spreadsheet for all of these cases where you can go in and update your status. So as you communicate with consulates or the NVC, you can go and give updates about what date you did that and what the response is. If you get scheduled for an interview, that information is critically important to us. So we really need to know if cases are moving, right? Because that's really how we know we can gauge how the mandamus is doing. If nothing is moving, then we know where we are. If half the cases are moving, we know which cases we need to push. So it's really important that you do your job to update those status reports. Don't send us emails because literally they get buried. They really do. We have thousands and thousands of plaintiffs, so they get buried. It's not helpful to send us an email, but do update the status report. Then the second piece is, here's what we now know. Remember I told you that the position of the Department of State changes all the time? Here's what we now know. We're not the only ones filing these lawsuits. These lawsuits are happening all over the country. The backlog is getting bigger every day. It's now estimated it's close to 3 million cases in the backlog. And so we were told by 2 different U.S. attorneys now that they are no longer settling mandamus cases within 60 days. They have been instructed by the Department of State to litigate mandamus cases. And the Department of State headquarters has provided them a template motion to dismiss that they are to file in all mandamus cases. So the world of us settling these within 60 days is gone. It's over. And so that's what we can expect, is that we are going to get a motion to dismiss on Penn v. Blinken in 60 days, and we're going to have to respond to it. We can anticipate what the arguments are going to be. Consular non-reviewability, which doesn't apply in mandamus cases. That you have to sue consular officers individually, which is nonsense. We can anticipate the arguments that are going to be made, and we're already drafting the response brief, but you should know that this is another area where Department of State has changed their policy. But that doesn't mean that your case won't move. That doesn't mean that you won't move, because they're going to still try and moot out as many of you as possible.
Yeah, exactly the point I was going to make. I mean, we're still seeing movement from individual plaintiffs on these cases, on the Egypt case, on the Brazil case. So we're seeing movement. So, that's their stated position. And just like we saw on the other kind of side of things, where they're like, yeah, we'll give everybody the highest priority. Now they're saying we won't do this, and they do the opposite. So, anyways.
All right. What about Moscow? Anyone want to talk about Moscow? What's going to happen with Moscow?
Yeah, I actually heard from, well, first of all, Moscow had announced that May 12th was the date that they are going to stop working on visas completely, except in maybe emergencies. But I had a client who was in contact with them and was told that they actually already stopped working on visas. So the question is, where does that leave people, and where does that leave plaintiffs? Well, just because a consulate has shut down for diplomatic reasons or COVID reasons or anything, it doesn't mean that the government doesn't have a duty to adjudicate an application that's been filed. And so part of the ask, if this remains the same for any of these cases, might be, hey, you need to facilitate a transfer to a consulate that will adjudicate our clients' cases. And so that's where I think this is headed. We've told people that it is a good idea to start creating a record of making transfer requests, even if they're going to get denied, and keeping them so that we can submit those in evidence that the government is not facilitating the adjudication of these visas. But that's probably where it's headed for Moscow. It's not looking promising right now.
And we have heard from several plaintiffs that we're going to be, let's say this, is that we anticipate within this week or next week, we will be filing another mandamus against the consulate in Moscow. We've gathered sufficient plaintiffs to do that. It's being drafted by Cook and Baxter as we speak, and it will be filed. We have heard from several plaintiffs in that lawsuit that they were successful in getting their cases transferred to Warsaw. So we know that Warsaw is at least accepting cases. And so that's one solution. If you're able to get your case transferred before we file, we will refund your money and dismiss you from we won't file you in the lawsuit. Once we file the lawsuit, then you're in the lawsuit. But if you can get it transferred before then, we would refund your money. What if, Aaron, another question that's in here is, my spouse is from Georgia. Could I possibly seek to get my case transferred based on my spouse's nationality?
Yes, possibly. So each consulate's going to make their own policies on which cases they're going to accept as transfers. Some only if you're a citizen of that country. Others only if you reside or have some other ties in that country. Some have made pretty blanket statements saying that they're not accepting transfers at the time. So I don't know what Georgia is saying. That's the consulate that really, the receiving consulate, the one that you're asking to transfer to, they're really the ones who control this. So I don't know what they're going to say, but I think it's worth an ask.
All right. What about the Cairo spouses case? So we have the Cairo K1 case, which is, oh my gosh, Yaqub V Blinken, and we have the Cairo spouses case, which is Abdul Wahid V Blinken. Any updates on that?
So Ryland is the lead on there, but he's not here. As
I can give the update. It has been filed. The summons has been issued, which means that, and properly served, which means that the government has been served in the case, and now they have 60 days to do something. As I indicated before, we anticipate that they will do something. They're going to file a motion to dismiss. And so Ryland did call today to find out if the U.S. attorney has been assigned to the case, and so far it has not been assigned. So we will call back again next week and can start making phone calls and negotiate on your behalf. All right, let's see. Zach, maybe you can help with this one. This is sort of a non-related question, but an L1 had an interview at the consulate in Paris and was refused an NIE. The consulate in Paris is forcing non-immigrant visa applicants who have already undergone an in-person interview to book another appointment. Earliest availability being December 2021. Yeah,
so first off, there's long or going on behind me, so if that's drowning me out, I apologize. Yeah, Paris has been really backlogged, so it's getting louder and louder. It's been really backlogged, so the appointments are getting pushed out further and further. Being denied an NIE, I mean, at this point is kind of a death sentence for getting your visa anytime soon. That said, I mean, this is kind of exactly what Kinsley is about, saying that you can't be denying people based solely on these proclamations. And if we're successful with Kinsley, it's possible that we could maybe get consulate to practice in a different way, where it'll reissue visas rather than having people come in and re-interview. I guess there's no guarantee on that, but something that's at least I guess a possibility. Besides that, I mean, if you were able to try to get a new appointment at a different consulate, that's something I would also definitely try to do. But yeah, Paris has been just extremely behind on appointments, and we're seeing scheduling so far out into even next year now. So unfortunately, not great immediate next steps, but I guess stay tuned.
Yeah, I mean, I don't know if you have an attorney or not, but if this is your case and you don't have an attorney, you should definitely get one. There are some strategic things you can do with regard to the NIE, focusing on critical infrastructure, making sure that you're looking at the Department of Homeland Security guidance for what industries constitute critical infrastructure when you're making your request. The other thing that I know is that there are some airports that are doing original requests for NIEs, even if you've been denied at the consulate. So, for example, the airport in Atlanta, Hartford International, is doing NIE requests at CBP. That's really risky, obviously. If you get turned around, you're going to end up back on an airplane. But that's another option. The other thing that I've heard is that you can schedule an appointment even if it's December 2021 and then request an expedite. And so if you have a reason to request an expedite, critical infrastructure reason, a business reason, that some consulates will schedule you more early, even if you're scheduled out to December 2021.
And I guess
all those reasons are why you really should consult with an attorney if you don't have one yet.
Yeah, and every day I would check to see if there's an earlier appointment slot. Things open up, so it's possible you could get something earlier if you keep checking.
All right, some of these questions we've already answered, so I'm going to skip through them. This is a good one. You know, one of the problems we've had with diversity visas, Aaron, is that it's not only cases at the consulate, but cases that are sitting at KCC, right? And some of these people have really low numbers, and you know they should be moving. But now that DV has been the lowest priority, what do we do with KCC?
Yeah, and this is Brandon G, who might be Brandon Go, but I'm not sure about that. So if you are, hi Brandon. Let's see, the KCC, yeah. Now that the visa bulletin says that they're current, KCC should be processing the cases, right, and forwarding them along to the consulates. To the extent that they're not, that's part of what we're asking the judge to order. Not just that the consulates do their job, but also that the KCC does its job. It's part of the Department of State that we have sued about this. To the extent that you're emailing KCC and the consulate and getting those automated responses, I know it's frustrating. We get those responses all the time too. It's super frustrating. But just keep in mind, you're doing a good job when you do that by creating a record. So you keep that record as an exhibit that can be filed and necessary, if necessary in the case, to show that you know they're not doing the work that they've been paid to do with your application fees.
And any updates in terms of the litigation and strategy in the litigation, Aaron, with regard to KCC?
Yeah, so we'll be filing, the next thing that actually gets filed in the case is the amended complaint. And one of the things we're kicking around doing is adding the KCC as a named plaintiff. In my opinion, it's not really necessary. We may do it. Named defendant. I'm sorry, named defendant, I misspoke. In my opinion, it might not be necessary because they're a constituent part of the Department of State who's already been sued. But we may decide to do it just to as kind of a belt and suspenders type approach. So we definitely are aware that they are part of the problem, and we'll be drawing Judge Mehta's attention to that.
All right, this one's back to Zach. Priority date is current, based on prior I-140. Perm is in process with the current employer, and the prevailing wage issued came out $10,000 more than my current wage. The employer has more than 500 employees and profitable with more than 300 million. Will it be an issue at the I-140 stage or the 485 stage regarding ability to pay?
I mean, it depends, I guess. I think with a $300 million revenue, there's not a lot to argue on the government side saying that there's no ability to pay, and even beyond that, the government can look beyond net income on the tax returns. If this was my case, I wouldn't be particularly concerned about it. Even if the company just put together like their financial statements and had those audited, it would be. There's so much there that you could use. Cash flows. There's just so much. I would not be worried about it at all.
Yeah, I agree. The case on ability to pay is a case called Matter of HIRA, H-I-R-A, and it kind of outlines the different ways that a company can establish ability to pay. And one of those is by proof that they are currently employing you, right? So if they're currently employing you and paying you a wage that they're able to pay, then it makes sense that in the future they'd be able to employ you at that wage. So I agree with Zach, this is not a concern. If the concern here is that the wage came out higher than your current wage, remember that the recruitment was done based on the wage at the time it was determined. So that wouldn't impact recruitment. And it's an offer of future employment. So, the wage really doesn't have to be changed to the advertised wage until the time that the adjustment is approved. So, all right, next question. Aaron, how did Judge Mehta respond to the argument that we would like him to reserve 55,000 visas, even if it's after September 30th?
Yeah, he didn't. We didn't get into the merits. This was about scheduling. But what we know from the Gomez case is that he is convinced that he has the authority to reserve visas beyond the fiscal year. And so if he had it in DV 2020, why wouldn't he have it in DV 2021? That's partly why we feel good about our arguments.
Another Go question is, the government lawyer seems to be really accommodating. What do you think that they're going to work with us? Because it seems like travel.gov seems pretty hostile to DV 2021.
I would agree with that. Travel.gov does seem pretty hostile to DV 2021. Yes, the government lawyer is one that we have worked with on other cases, and he is very professional, very responsive, and it's honestly very nice to work with him on these cases. That only goes so far. That doesn't mean that he's going to give us everything we want. He has a department that he represents that tells him what position to take and what to litigate. So does that mean that the government's going to roll over and give us everything we want in the case? No, I don't think so. But yes, he is accommodating.
All right, another question. This one's on Kinsley. So as you recall, Kinsley was a straight-on challenge to the proclamation. Right after we filed it, the proclamation, there was NIEs granted for, wide categories of people. And so the question here is, since there's not a mandamus component to that lawsuit, can we separately join a London-specific K-1 mandamus suit? That's the first question. The second question is, they've been told that when we get to 100 couples that we would file a mass mandamus, and that we're at about 50. Is that the case? Anyone want to take this?
So yeah, if we have 100 plaintiffs, we would file. I'm sure there's some confusion when Chuck said that it would not be the case. That's been our policy, that we'd be good to go with 100 plaintiffs. I say with the two real decision makers also on the call.
Right. No, we would definitely move forward with 100. You could join you could stay in the Kinsley suit. Yeah, you could stay in the Kinsley suit and file a mandamus, because we have not filed a mandamus. What you could not do is, if you were in a separate mandamus lawsuit like Milligan, you couldn't then file a London-specific mandamus, because the claims would be the same in those two cases. But yes, you could separately join the London-specific suit. If you go to Greg's law firm website, which is visalaw.com, there is a wait list, and the wait list includes the London lawsuit. So sign up for that lawsuit. If we get to 100, we will file it. All right. Let's see. Do you see any changes? All right. Any change? Do we predict any change in Manila's position with the 26 remaining round 2 Milligan plaintiffs, especially now that they've been served with the Ramirez lawsuit?
I mean, if it's just predictions, yeah, I do. They have already kind of signaled that they're changing their tune a little bit. They put out a tweet saying, "Oh yeah, K1s, we're definitely going to be prioritizing those." We have seen a smaller amount, but some movement on plaintiffs in Manila. The issue is just it's a problem consulate, and so things, even when they do change, are going to be slow. I'm gonna mute myself again.
All right, just about 15 couples from Brazil have been scheduled for interviews. So this is great news. This is what we were talking about, is that, when we file, people tend to get scheduled right away. So this is an example of that. The real important question is, where do we upload that info? And they haven't received a link. So Jennifer, can you reach out to Greg and make sure that he sends an email out to all the different plaintiff classes for Penn and Yakub, and make sure that they have a link to the status report. That's what we really need. When you all ask us what's the status of cases, really the only way we can know that is by you self-reporting. So that would be really helpful. Okay, let's see, same thing, need access to a status report site. I'll make sure that you get that. How can you submit a transfer request if you reside in a country with only one embassy? So you just basically write to the embassy and you ask them to transfer it to another consulate that's convenient. So, as Aaron said before, you're less likely to have that happen if you don't have some connection to another country, like you reside there, or your spouse is from there, or you have dual nationality or something like that. But in a case where the consulate is completely shut down, such as Moscow, we think we're on pretty good ground to argue that you can't just shut off visa processing because of diplomatic reasons. So it's hard, I'm not going to lie, but you should try and make the request and document it, because that's going to help us later if that becomes part of the prayer for relief that we ask for in the court. Okay, didn't understand what we meant that we need to respond to the Penn lawsuit in 60 days. What we mean is that when we file a complaint in a lawsuit and the government is properly served, that's what starts the clock for them to submit some sort of response to the lawsuit. And so in Penn, they've been properly served right now, which means that the 60 days is ticking, and we're waiting for them to get back to us on what their plan is with the case, which we know will be a motion to dismiss. Aaron, that was Brandon Go. He says hi. And thanks for the great work, by the way. Would a positive decision in Kinsley apply to non-plaintiffs? Yes. Positive decision in Kinsley, striking down the proclamation, would basically strike down the proclamation across the board universally. Just so you know, our plan in Kinsley is, Zach, you want to fill us in on what the plan is on Kinsley?
So it'll be an early motion for summary judgment, more likely than not. So what we'll do is we'll say right off the bat, hey, we should win. Judge, come on, let's make a decision. There's no facts in dispute. Let's decide this case right now. We don't need to go back and forth with a preliminary injunction. We don't need to have any sort of preliminary relief granted. We don't need discovery of what the government's documents are. Here are the facts. There's no dispute about the facts. We can argue about the law, but every other judge has said that we win. So can you please just strike down this practice across the board?
Awesome. Okay. And let's see. Nicolette Glazer said there's some sort of discretionary transfer for DV2021. All transfers are discretionary. So yes, she's just calling it a discretionary transfer, but it's the same thing we're talking about. It's just asking them to transfer. Do we think Milligan round 3 will get their interviews this year? It depends on the consulate. It depends on COVID. It depends on, how the Department of State changes their policy on a weekly basis. It depends on the lawsuit and how quickly the lawsuit moves. It depends on a lot of factors. I would love to say that you'll get it this year. And I think that if the pattern of how these cases have been processed so far from the time that we started this lawsuit in October pans out, then I think that it's a good chance that you will. But that's all I can tell you. Let's see, any updates on Go? We've already talked about that. Apparently we froze. That's all the questions that we have. Any other questions before we sign off? Any final thoughts from our esteemed panel of guests today, from Joseph and Hall? All right.
Not for me. Thank you all.
All right. We'll see you next week. Same time, same bat channel. Talk to you soon.
Bye, everybody.